Record. Hi, I'm Chris Colvin. I'm the founder of In the House. Welcome to our monthly meeting of our privacy and cybersecurity working group. Each month we meet at approximately the same time and approximately the same day of the week. And I'm here with my co-host David Heckler. We try to have guests that have interesting perspectives on cybersecurity and privacy issues. I'm delighted today that our guest is Professor Eric Goldman. And I will now pass the torch to David. And David, if you could introduce our guest a little more in a little more detailed fashion, then we'll move forward with our program.
Sure. Just to reiterate, because we're getting people still joining us as we speak, this is being recorded. If you don't want your image to appear, you can turn off the video, bring your cursor down to the bottom of the screen. You have lots of functions there. If you want to ask a question in writing, if you click on chat, you can do that. I'll monitor and ask the question for you. But we encourage you, as Chris just did, to ask yourselves any questions you have after our guest speaks for maybe 10 minutes. And our guest is Eric Goldman, a professor at the University of Santa Clara University School of Law. He is a pioneer in teaching internet law and privacy law. And privacy law has been front and center throughout the world, really, for the last couple of years. And certainly California is ground zero these days, ever since the California Consumer Privacy Act passed. And it doesn't go into effect until January, but I'm sure you're all aware of it. And I've asked Professor Goldman to talk a little bit about where we are with all these amendments we're hearing about periodically, and then where the regulations are, because they're not even going to go to be enforced on January 1st, 2020. So rather than my start answering for him, Professor Goldman, take it away.
Thank you, and greetings from California. I'm delighted to be among this group. I recognize some of the names of participants. It's a community that I think I've had a chance to engage with before, but I'm glad to be a part of it today. The California Consumer Privacy Act really caught everyone's attention in part because of the fact that it's, I think, the first universal, across all consumers, across all industries, privacy law that has been enacted here in the US. Obviously, we've had many privacy laws enacted before, but this law cuts across everyone and everything, in fact. And so it really has grabbed the attention of the nation and the world because of the potential reach of the law and scope of the law. Just a quick refresher on law, I know most of you are familiar with it, but the law purports to create 5 new consumer rights. It creates a right of disclosure. There's various things that consumers must be told about the business's practices. It creates a right of erasure, that consumers can delete their information in certain circumstances. It creates a right of data portability, that consumers can take their data to third parties in a portable format. It creates an opt-out from data sales. And sales are defined quite extensively. It's likely that pretty much any business transaction involving moving consumer data would qualify as a data sale under the law. And the consumers have a right to opt out of those data sales. And with respect to minors, there's an opt-in requirement. Certain minors, again, there's some age cutoffs. The 5th right is the right to be protected from discriminatory behavior on the basis of consumers exercising their rights. So we'll call it an anti-discrimination provision. There's a 6th, quote, right of interest to this group, which is a private right of action for certain types of data breaches. And we can talk about that more if you want. So these 6 new rights cut across all consumers and currently employees as well. And they cut across all businesses that are dealing with California residents. The law has a fairly expansive reach to say that if you're dealing with a consumer in California, then the law purportedly applies unless you can find an exception to it. The law takes effect on January 1st, 2020, but that's a little bit misleading. we're not entirely sure all the different things that are going to happen or not happen on January 1st, 2020. What should happen is that the private right of action comes into effect. So data breaches involving California consumers will be potentially eligible for litigation at that time. Otherwise, the law is enforced solely by the Attorney General's office, which is really playing catch up here. The Attorney General didn't ask for this responsibility. They weren't well consulted during the drafting process. And so the Attorney General has been scrambling to catch up with what is a potentially major chunk of their portfolio over the long term. The law says that it will come into, it will be allowed to be enforced by the Attorney General at the earlier of 6 months after the Attorney General issues some rulemaking under the law, or July 1st, 2020, whichever comes first. The Attorney General is, has said that they will issue their first draft of their rulemaking in early fall. I'm just going to pick a date for now. Let's target October 1 as the date when we expect that their first draft of the rules will be issued. There will then be a comment period. There will be a final rulemaking procedure. There's absolutely no way that that will be done by January 1st, 2020. So the Attorney General will have the right to enforce the law starting July 1, 2020. Now, there's no deadline on when the Attorney General must have the rules finalized. So one scenario is that the rule will be finalized, let's just pick a date, June 30th, 2020, or any time thereafter, at which point there will be absolutely no chance for companies to do any effort at all to comply with the rulemaking that the AG has set up before the law can actually take effect. So there's a collision that's going to happen in our future, and we don't know how bad it's going to be. Even if the Attorney General issue their final rules on January 1, 2020, which they will not do, the amount of compliance work that's going to be spurred by that is going to be probably pretty significant. So it's going to be a scramble in the first half of 2020, no matter what. We just don't know how long companies are going to have to scramble, and we don't know if really they're going to have a chance to even be prepared for July 1, 2020, when the Attorney General can start enforcing the rule. Now, if the Attorney General has been dilatory in issuing final rules, it would be unfair of them to go and then turn around and smack companies for not having complied with late issued rules. But they would have a legal right to do so. What they choose to do is unclear. The one thing I'll say that it may not be obvious from the outside is that in general, the Attorney General's office views itself as a litigation shop. It doesn't view itself as a DPA-style entity as we're familiar from Europe. So they're not looking right now to play ball with industry. That's not really where their head's at. Their head is, we've been hired to enforce laws, and we enforce them by litigating. So unless there's a cultural change, there's another collision coming up, which is what happens when the rules are in place. If you haven't had a chance to comply with them, they're thinking we're in the business of litigating. I'm not quite sure how they're going to play that. I'm hoping that they will get a cultural adjustment to recognize that this needs to be a conversation with industry, not simply an enforcement crackdown. To give you a sense about why these rules are so important, let me just highlight one example of something that the Attorney General is expected to issue rules on. We mentioned that the consumers have the rights for disclosures, for erasures, for data portability. They get to access, see, delete, and move out or take away their information. One of the Attorney General's obligations is to create a standard for what constitutes a verifiable consumer request. How do we know that the consumer asking to see their data, to delete their data, to port their data, is actually the person who is the subject of the data? The law doesn't specify. It kicks it all to the Attorney General's office. That's a really important question, because if that's standard is miscalibrated, you've got hackers and miscreants galore who are going to be able to get consumer information, all the good stuff, because the disclosure standards are too lax. So that's the kind of thing, everyone's very interested in that question. It might take a while to build a process and or technology to enforce whatever the standard is for verifiable consumer requests. You might not have that standard before the law actually can be enforced by the AG, or if you do, you might not have time to comply. The other moving part to this dynamic is that the California legislature is considering, and I'm just going to pick a rough number, let's call it a dozen amendments to the law. Now, the reason why it's kind of hard to count, there's a bunch of laws that are sitting next to the Consumer Privacy Act, and so I don't know how you want to count them. Some of the bills might already be combined, or they do, some are narrow, some are broader. So there's some counting problems with that. But the point is that there's, let's pick a number, a dozen or more moving parts to the law that the legislature has targeted for potential amendment. The California legislature takes a hiatus in July and August, for 2 months in summer, roughly around then. Things are kind of going to be quiet for a while, and then it's going to hit really, really fast before the deadline in September to get everything to the governor. So there's going to be a lot of movement at the end of summer with bills that are going to pass or not. And depending on what those bills do, then all the compliance work that you're doing may or may not actually be relevant at that point. We're not quite sure what's going to happen. To give you just one example of the proposed amendments, one proposed amendment is to take employees out of the definition of consumer. That's a good amendment. I don't know anyone who really opposes that, although the consumer advocacy groups have fought tooth and nail on even the smartest, most savvy amendments. They still view it as a denigration of the rights. But taking employees out of the bill makes a ton of sense. However, if you do that, that's going to change your compliance program quite a bit. If you built it to cover employees, you're going to have to then reverse engineer that out. If that doesn't pass and you haven't accommodated employees, you're going to be scrambling to build your compliance program to also include employees. So that single amendment alone is an example of something that's going to have some potentially significant bite. I will also point out that though we expect the majority of amendments to the law to take place in this legislative year, there's nothing to say that the legislature can also consider amendments starting in 2020. So they could start the bill amendment process in January 2020 and take it through the normal cycle. So it is possible that even in 2020, we're going to see amendments to law that will change compliance programs. This is literally trying to fix an engine of a jet plane as it's flying at 500 miles per hour. I'm going to take a quick break here. David, how do you want to see this conversation?
Well, I've got two questions that are on the little chat window, so
Okay,
I will start with that. Let me just add that although CCPA makes a lot of sense as the subject we're discussing now, that's on everybody's minds, I don't think the audience ought to, basically limit themselves to just this subject. Privacy is a big deal to everyone, and they don't even have to limit themselves to privacy, because you are the Delphi of Oracle today, and you can answer any question that comes your way. Let's start with this one. Since the California AG views itself as a litigation shop, to use your words, does that imply that they will likely be going after larger players with a bigger footprint and therefore bigger consumer privacy impact?
Super question, and we don't know. And one of the reasons why we don't know is I'm not even sure the people who are going to be doing that work have been hired yet. Literally, the AG's office is building up its entire team. I don't want to say from zero, but closer to zero than not. So we may not even know how they're going to define the roles and who's going to occupy those roles and what biases they're going to bring to the table, as well as what instructions they're going to get from on high, whoever is going to be the big boss on this question. Presumably the Attorney General, but the Attorney General might very well delegate.
I got on it late because I got stuck on the phone with it.
I think someone's joined us.
This is where we got mute.
I had to exercise my godlike moderator
Yes.
power to mute somebody. So,
Yes.
I'm sorry, back to the question of how is the AG going to set its enforcement priorities? So after the team is built, there are really two models of prosecutorial approaches. One is to go after the big fish because that's where you get your biggest bang for your buck. The other is to go after small fish who aren't going to fight you and establish a wall of informal precedent. This is what the FTC does a fair amount when it's in new territory for it. It goes after people who have no money to defend, who have the worst practices, who are the shadiest folks, and gets them to settle, and then takes that settlement to the next player and says, look at what they've already agreed to, now you need to agree to this as well. And just keep rolling that up until you get to the big folks. But that can take years to develop that wall of informal settlements acting as a form of guidance to the industry. So I don't really know which way the AG's office is going to go, and I don't know if it's knowable today, given that we don't even have the infrastructure built.
I had a related question. Since that was my question, I'll just jump in if that's okay.
Okay.
With regard to how how the sausage was made in the legislature, were there lobbyists from some of the big four internet companies there submitting their ideas? What was their involvement with that process?
Right. So for those who don't know the sordid history of this particular law, it's a great story that will be magnified and stretched in the retelling. The oral history of this will become quite fabulous. But the short story is that a single California real estate developer, a guy named Alistair McTaggart, I trust many of you have either heard him or run into him, was able to qualify a ballot initiative that became the basis of the California Consumer Privacy Act. California has an open ballot. All you have to do is spend enough money to get roughly 750,000 signatures. It costs about $1 a signature to pay the people to do it. So if you have a few $1,000,000 to do all the various work, including signature gathering, you can pretty much get anything onto the ballot here in California. Once he got onto the ballot, he offered the legislature a deal. He said, you have two choices. Either you can pass this law in the next week before the ballot's printed, in which case I'll take it off the ballot, and then you guys can continue to manage this as legislation, or we'll put it to the voters. If the voters pass it, it has a supermajority to amend, and the legislature, you will be out of this business permanently, in effect. You'll have no further voice on consumer privacy forevermore because this law will now be untouchable to you. It wasn't a hard deal for the legislature to say, we like the one that retains more of our power than less, right? I mean, this is not really, just follow the self-interest. So there was a 1-week period when all the lobbyists got to tear into the ballot initiative language, but they couldn't go too far because Alistair McTaggart effectively, remember, non-elected person, this is someone who I never had a vote on, had a de facto veto power. He said, if you do that, I'm keeping this on the ballot, good luck. So there was a negotiation that took place between the ballot certification and the removal from the ballot and passage of the law. But it wasn't really the kind of vigorous negotiation you would expect for a law of this magnitude. 1-week period, everything took place behind closed doors. There were no legislative hearings, and Alistair McTaggart had a veto power. So some of the big internet companies were involved in lobbying during that period. Some of the other business interests were involved. The consumer interests were also involved. Everyone who could get in the door was in the door, but it was such a small fraction of the overall community. There are thousands of business niches who were not represented in that 1-week negotiation. That's why this package of amendments that's going through the legislature now is so important. This is the first time that those people have had a chance to actually speak up about the law. And when the first hearing was held in the Assembly in February, that was the first public hearing that this law had ever had after it had already been on the books for over half a year.
I'll just add to that story. It's an amazing story that Cambridge, the Facebook Cambridge Analytica scandal occurred in March. And that was when all bets were off against Alistair McTaggart. I mean, he didn't even have enough signatures at that point yet to actually guarantee that this was going to be a ballot initiative. But when that scandal broke, everything changed.
And I would point out that one of the many frustrating parts about the law is I don't think the law really addresses the Cambridge Analytica scenario. So that was the fueling animus towards the privacy considerations, and it may not even be well addressed. I will also add that so much of the rhetoric is focused on the big internet companies. This law applies equally to online and offline businesses. So I always talk about every time you're thinking, I hope this law sticks to Facebook, also think about it, I hope this law sticks to my local pizzeria, because the law treats them as the same.
I've got a couple more questions in our chat window, but I don't want to preempt our participants here today. So does anyone else have a question who wants to step forward and ask it? Okay. With regard to the private right of action, are there incentives for the plaintiff's bar to get involved?
Is this like a softball or something? I love that question because the plaintiff's bar is keenly interested in this particular law. They will be the heaviest users of it by far. So the private right of action it's a really goofy thing. So let's start with the baseline. That the law applies to data breaches. Now, there are some exceptions to that. If the business has encrypted its data, whatever that means, then it has a safe harbor. If it redacts its data, whatever that means, it has a safe harbor. And if it's deployed reasonable security practices, then it has a safe harbor. So the plaintiff's bar is going to have to navigate some really tricky grounds. It's very possible that many businesses will have encrypted or redacted their data. Or even if they haven't, there could be a very lengthy battle over what constitutes a reasonable security measure for purposes of this law. And so the plaintiffs lawyers don't really want to get into that quagmire about whether the practices were reasonable or not. Furthermore, the law allows the business to, quote, cure a data breach to avoid some of the worst damages. Now, how does one cure a data breach? I don't know. I don't think that'll ever be invoked. But it's another barrier because, in theory, the plaintiff's lawyer could get the plaintiff's bar get all fired up to bring a lawsuit, but then they subject to this cure period. And if the business can adequately cure or convince a judge that it's adequately cured, that could take away the exciting damages the plaintiffs are chasing. The carrot here are a couplefold. One, because it's a state law and it has statutory damages, there's potentially really huge numbers. I'm sorry, I didn't remember the number here. You guys might remember. I think I want to say it's like $750 per consumer, for instance. Please don't quote me on that. I'm sorry. It's a number. It's measured per consumer per incident, which if you add it all up across millions of Californians, that number is going to get to be a very large and attractive number. Second is that because it's not in federal court, it's quite possible that there won't be any actual harm requirements that the consumers will show. If they can show that the data wasn't encrypted, wasn't redacted, wasn't reasonable security measures, they get the statutory damages without showing them any harm whatsoever, without having the kind of Article 3 standing problem that plaintiffs have had. So this is a gift to the plaintiff's bar. They can get over the Article 3 hump. They can have statutory damages that are going to be enormous, and they can put the businesses into a massive quagmire where they're just going to want to settle. So yes, what I think is going to happen is every single data breach that happens after January 1 is going to have a California private right of action litigation brought as part of it. For the idea, like, if you can't get all the other classes formed or through the various suits, at least this one should be good to go. And the plaintiffs' bar should be under obligations to prove or adequately allege that there was an encryption or redaction before they even file the complaint. They're not going to do that. They're going to say, we believe, based on our very limited and sketchy research, that there was no encryption or that there was no redaction. Therefore, now we should at least get past the motion to dismiss. You got to take our belief as true. Let the business rebut that after the motion to dismiss has already been denied. And by that point, the businesses are going to settle. So we are going to see a growth of the plaintiff's bar. We're going to see litigation after every data breach here in California, and we're going to see a lot of businesses choose to settle.
Wow, I mean, you think of just in terms of the numbers of prospective plaintiffs, it could dwarf like asbestos litigation, right, in the 80s and 90s, just because of the pure numbers.
I mean, just think about how much fun we've been having with the TCPA, and the private right of action for data breaches in California should make that look like child's play. I would expect this to be dramatically more active than the TCPA litigation, which is already, I would think many of us would feel, completely out of control and not in a productive way.
Okay, the next one is one that you've talked about a lot, I know, with me, in addition to elsewhere. What are the main areas of conflict and overlap between the CCPA and the GDPR?
Yeah,
and work the word household into your answer.
Yeah, no, I'll definitely mention that. So like the GDPR, the CCPA is across all industries, across all consumers. So it has the same animating architecture, and it thinks in terms of these consumer rights, which I think might also have some parallels to the way that we think about the GDPR structure around consumer rights. And there is some stuff that we haven't talked about that tries to get businesses to bake in privacy and security by design to try and make more people feel more responsible for taking privacy seriously as part of their job. So, for example, there's some training requirements that are in the CCPA that are somewhat analogous to the idea that you're supposed to take privacy seriously under GDPR. So there's definitely a lot of parallels. The main heart of the law, though, is different. The GDPR is based on you have to have some lawful basis for processing consumer data, of which consent might be one of them, but don't rely on that one. So find something else unless you really want to have the negotiation with your DPA. So at the heart of it is this idea that you have to have some grounds for processing consumer data. And that's not the heart of the CCPA. The heart of the CCPA still has these consumer rights, but take the opt-out of data sales, for example. The starting premise is you can sell data. You have to give consumers the right to opt out, but you have the default right as the starting premise. So in that sense, it's different from the GDPR, just in its architecture. It tried to solve things a little bit differently. And Alistair has talked about why he did this, and he basically got scared off from going to GDPR route because of the First Amendment. He felt like if he had restricted data flows in a more aggressive way, that would create problems for the law constitutionally. There are lots of other examples of littler points, but really important points that distinguish the CCPA and the GDPR. Let me mention two. One, this question about employees and how employees are handled. We're not sure whether that's going to end out and how it's going to be the same or not as GDPR. Second is that under the California law, the definition of consumer of personal information includes information about the consumer or their household. Now, this is a really bizarre concept, and most of the privacy experts are baffled by this. What does it mean to protect household information as if it's the consumer's personal information? That doesn't really work, because when you're talking about a household, you're almost always talking about other people. When you're talking about other people, now that means that my personal information is designed to include information about other people. And this creates some real conflicts with the consumer rights. So for example, I have the right to delete my personal information, but if my personal information includes household information, I have the right to delete information about other people that might affect their experience in interacting with the business. So in a sense, it reaches out from really treating one person, one data set, now saying one person, maybe more than one data set. We might be talking about other people's data sets as well. So the word household alone, that single word, guarantees you're going to have to re-architect your GDPR compliance program because of the fact that anything that you built to comply with GDPR didn't contemplate that a consumer might be managing information about their household, which includes other people. In fact, the GDPR wouldn't allow that. You can't access, see, port other people's information. That would be inconsistent with the GDPR. So the word household alone is just one of the several examples of really small details that end up making the law very structurally different.
For some reason, the word penumbra is popping into my head from law school. So
it's a great example because that is about households as well, except
right.
It may or may not include other people's information. But the way that the law is defined here almost certainly includes other people's information. So your penumbra isn't just if you live as the only person within the household, you get your household and then some stuff around your household.
Right.
Here we're talking about you might be able to manage grandpa's information or vice versa, or your adult roommate's information. So you guys are cohabitating because you can't afford to live on your own, the millennials curse. So the millennials now can go and mess each other up and their roommates up, no problem. You got separating spouses, same kind of issue. They can really mess each other up.
Very interesting.
If there are no other questions right at the moment, I'm going to ask you one. There are 3 posters behind you. They are not there by accident, correct? Oh, yeah, I guess the 4th one is so small I can't even tell what it is. can you introduce us to the posters behind you, which have an IP litigation connection?
Thank you for the invitation. Yes, they are not by accident. I feel a little bit like the BBC dad. Do you remember that video?
Yeah, with the baby.
Babies came in and he had laid out all his books so cleanly, and then the baby comes in and starts tearing all that up. So this is all carefully curated. Last year we moved into a new building. The law school did, and when we were in the old building, which I had occupied that office for 10 years, I never put anything up on the wall. But now that this is my permanent home, that I expect to be here for a very long time, I finally put stuff up on the wall. And what better to put up on the wall than IP artifacts, artifacts from litigated cases. Up here you can see, this is the Three Stooges. This was a case litigated over their publicity rights. The artist lost. This thing is actually verboten content now. It's illegal for me to even have it. Thing behind me is the famous.
Good thing we're recording this.
All right, bring it. The thing behind me is the New Yorker poster, the bird's eye view of 9th Avenue by Steinberg. This is iconic, especially in your community. I trust everyone is intimately familiar with this poster. There was a movie poster for a movie called Moscow on the Hudson in 1984, Robin Williams. Can't say I'd recommend it. It was kind of like a midstream 1980s movie. But they did a version of this where they actually flipped it. They viewed the other direction. They looked to the east as opposed to the west. So here, it's towards China, Japan, and beyond, whereas the other one, they looked towards Russia because of Moscow on the Hudson, get it? So there was a copyright litigation over that, and the poster was found to infringe. And then finally, of course, everyone knows Naruto. This is the infamous or famous monkey selfie. Naruto took hold of a camera that the photographer left out, took his own photos of himself. I'm sorry, her.
The non-lawyer remembers.
Naruto, because Naruto took the photo, this poster is not owned by anybody. This is out of copyright, so I was able to get quite cheap on Amazon. You can find tons of things online. I'm not going to cut or anything. But no copyright on that one as well, so Naruto gets to hang over my left shoulder.
It was a creative idea to put the camera in the hands of the monkey, though, I think. So
I think she picked it up. Has she taken any other photographs that we know of? Because I think she might have a career.
Yeah, well, actually, Naruto took a whole series of photos, the monkey selfie series, all of which are out of copyright, all of which are available for you to find online. We just celebrated my stepfather's 91st birthday, and my sister and brother-in-law got him a birthday card that is of Naruto, one of the different photos. They didn't know that it was Naruto. They just thought it was really cute. And I said, I recognize that monkey. In fact, yeah. I know that monkey very well because she looks over my shoulder every day.
Well, I think we need Naruto 2.0. That's getting outdated. She needs to wear a GoPro and stream to Facebook Live, and that'll be the next.
Well, in fact, we have a whole genre now of animals taking selfies. This has become quite a thing. So there's a wide variety of animals that are now taking selfies, all of which, once posted, are out of copyright. You can go ahead and party on with any of them.
There were a couple, David, if you scroll down, there's a couple new questions.
Go ahead.
Okay, so we have a question. It is my understanding that CCPA also applies to Californians residing in the EU. How do global companies handle having to comply with both CCPA and GDPR?
Yeah, that's a good question. It's a good question. And if you will indulge me, let me just point out the obvious. We're going to have the same conflicts when we have other variations of CCPA adopted in the US. So you could have a California resident who's traveling to Iowa, and if Iowa has a CCPA variation of it for Iowa, you're going to have the same kind of conflict. So these kinds of conflicts are endemic in a nation-based or state-based privacy regime, given both the mobility of people as well as the fact that they can travel online and show up elsewhere. And all I can tell you is I think the answer is you have to comply with both. Now, that's not a particularly satisfying answer because literally there may be conflicts that cannot allow you to comply with both. We just mentioned one, this household situation, not permissible on GDPR, requirement on CCPA. How are you going to manage that for the same consumer? I have no solutions for you for that. But that is the conflict that's inevitable. Now, the way we need to fix it here in the US is we need a federal privacy law that preempts all these state laws. That will establish at least a national standard that will not solve the problem between the GDPR and whatever is done in the US. All we can hope for is either that we ultimately get a harmonized set of global laws that we don't have those kinds of conflicts in a material way, or that whoever the regulator is understands the fact that you had to make a choice between compliance program A and compliance program B and is tolerant and accepting of that. It's not a particular approach I would want to take, but it may be the reality that we live in.
Here's another one. What are the thresholds that a company has to hit before the CCPA applies to those companies?
So the CCPA defines a business as having one of three attributes. It is over $25 billion a year in revenue, or it derives 50% or more of its revenue from data sales, or it receives 50,000 personal information from 50,000 or more consumers in a year. Let's just work backwards through those. Let's work through those a little bit more in detail. So the $25 million a year threshold was designed to take out small businesses and maybe even some medium-sized businesses from the law. And that's great. Certainly, we know many businesses that will not meet that $25 million threshold. Now, because the CCPA purports to reach outside of California and govern activity taking place outside of the borders of California, in theory, this means that a $25 million a year business in, let's pick a place, Atlanta, Georgia, will be obligated to comply with law the first time they interact with a consumer resident, a California resident. In other words, the $25 million doesn't have to come all from California residents. There's a $25 million standard with the first dollar from California triggering obligations under the law. That's a mistake. That's a misarchitecture of the law. I have identified that many times. The people who will listen, nobody in the California legislature seems to care about that. I think that's one that ultimately will have to go to the courts if the AG's office chooses to bring those kinds of enforcements. The second standard, the 50% of data brokerage sales, is a pretty niche standard, but for anyone who's affected by that, that really is going to matter a lot. They need to pay careful attention. The third standard is the one that picks up everyone else. It says that the consumer receives for its business purposes data from 50,000 or more consumers. Again, we have the problem that those 50,000 don't all have to be from California. So you can have 49,999 from somewhere else in the globe. The first California resident that crosses that threshold is going to be covered. Now, some examples of things that might qualify as personal information that make that number look ridiculous. One, credit card information would qualify as personal information. So any business that collects 50,000 credit cards in a year is likely to be covered by this law. So think about that. If you have 137 credit card orders in a day, you will qualify for this law. That's why I talk about the local pizzeria. I don't know if they actually have 137 credit card orders in a day, but any high volume, low margin retail business is going to get screwed under this law because they're going to be picked up. Now, in addition,
can I stop you there for a second? What if a small business uses a backbone such as Stripe or PayPal or someone like that, so that they're not actually directly processing the information? Do you think they would be protected, or would they? It's probably too early to tell for sure, but what's your gut feeling on that?
I have to look through the statute. I believe the answer is that those people will be deemed to be what the law calls service providers. It doesn't use the GDPR processor controller distinction, but we might view this as the business is the controller, the vendor is the processor. There's different language in that in the CCPA. I don't think that's likely to get around it. I'd have to look if you could game it nevertheless. Let me just mention one more thing about the 50,000 consumer standard. IP addresses are almost certainly going to be defined as personal information under the law. That means any website that has IP addresses from 50,000 or more consumers, as long as one of them is from California, is purportedly covered by this law. Now, 50,000 IP addresses in a year is a trivial number. I'm sure that In the House gets well over that. I get well over that. my blog, which is brilliant, but it is not a mass market blog, gets well over that. And so this law picks up really tiny blogs, tiny websites, as long as they have any commercial activity, and I get about $300 a year of Google AdSense revenue. So I'm actually going to be covered by this law under the way it's drafted. And that's like the antithesis of limiting it to large businesses, right? This law really does reach to micro businesses because of the misarchitecture of that standard. That number, 50,000, should probably be more like 5 million or 50 million. That's the number that would be the appropriate standard. That's how far off the law is. Once again, don't think there's any movement in California to fix any of this.
So,
And
so
nonprofit,
unfortunately, David, unfortunately, we're running short on time. So I think we're going to have to make the next question, the last one.
just to clarify one point about what you just said, nonprofits are exempt. Is that right?
Nonprofits are categorically exempt from the law, which creates some really interesting dilemmas under law because of the fact that it's not clear what law applies to them. And if they're dealing with businesses that are covered, like if they're a nonprofit vendor to a business that is covered, there's a really messy analysis that takes place. I'm sorry, Chris, did you want to try one more before you?
Let's just try one last question, and I guess I'll ask it since we haven't gotten, I don't think I see any more from the group. My question is pretty basic, which is, if you're a general counsel, what are a couple quick sources of information just to stay up to date on the CCPA? I presume your blog would be a good resource, but what else should we be looking to just to stay on top of things for our clients?
Yeah, so my blog is brilliant, so you should definitely pay attention. No, in fact, one of the good things is that the AG's office has recognized the importance of keeping in conversation with the business community. So they've set up an email address where they're nominally trying to keep in touch with people. I would encourage people to go to the AG's page for the California Consumer Privacy Act. They have some resources. They have all the stuff they've done so far. And they also have an email list where you can sign up to get more information. And that seems like really low-hanging fruit. Keeping up with the California legislature is impossible. It is something I can't do. So I literally don't even have alerts set up to track the laws here. It is super difficult. So that's one where you're almost certainly going to have to rely upon your outside counsel or your political firm that's monitoring legislation for you to try and keep up with that. But everyone's paying really close attention to CCPA. So the good news is, if anything big happens, you're probably going to hear from 1,000 different sources, given that there's such heightened interest. So those are a couple of things I would suggest. If you have someone who's tracking legislation, ask them to pay attention to that. The AG's office for the rulemaking, and some of your preferred sources, including, if it's helpful, my blog, to see. I'll be covering every amendment to the legislation that passes. I will be covering the rulemaking as it comes out.
Oh, great. Well, thank you so much, Professor Goldman. Unfortunately, we're out of time. Thanks to Professor Goldman and my co-host, David Heckler. We do record these, and they'll be available at the in-house website, which is www.inthehouse.org. We'd love to have you back sometime, Professor Goldman, because this is really important material, and California seems to be one of the leaders in this area. So, again, thank you for your time, and we hope to talk to you again.
It's been a pleasure. Thanks so much for letting me join the conversation.
Our pleasure. Thanks, everybody. We will be having another call in about 10 minutes on cannabis issues, a different issue. But California arguably would be implicated in that as well. Given their history. So anyway, in about 10 minutes at this same number, you could join us again. So thanks, everybody.